Hello ladies and gentlemen, and welcome back to my YouTube channel. My name is April, and if you are new here, then kindly don't forget to look at my videos on my channel, and if you like what you see, then subscribe to my channel and don't forget to click on the bell notification button to always be updated whenever I post a new video. And if you are a returning viewer, then thank you so much for coming back. Today we are going to be talking about case briefs, basically what a case brief is, the purpose of it, and how to go about briefing a case. So if you're interested or you need this kind of information, then of course stay with me. The very first thing that I would like to say about this topic is that I'm going to be talking about it based on my experience as a law student at the University of Ghana School of Law. So basically how I went about briefing cases. And the reality is that even though there is a standard way of briefing cases, some people add a number of things which other people do not add into their case briefs. So the methods do vary, and that is why I'm just putting out this disclaimer, because this method is my method. And also I would like to put it out there that when it comes to briefing cases, it really is about you and how you go about understanding and analyzing information. What I mean by this is that at the end of the day, no lecturer, no teacher, no one is going to be looking at your case briefs and marking them or asking you to write a case brief in an exam. That doesn't happen, generally speaking. At least I have never heard of it personally. So a case brief has to be tailored to you, meaning it has to be written and structured in a way that you understand. So if my method or someone else's method, maybe a lecturer's proposed method, doesn't suit you, once you read and brief more and more cases, you have to develop a structure and a briefing method that is unique to you, so that suits you. If you like to go about it in this particular way and it actually works for you, that is what you should use, rather than using a particular format like mine, for example, and sticking to it even though it doesn't help you in any way. So please just keep this in mind as we progress throughout this video. So a case brief is basically just the notes that you take concerning a particular case, or the summary of the important parts of a case. And this is very, very important because in a common law system, which Ghana pertains to, we study the law based on cases. So meaning your case briefs are a very, very important part of your study of the law. If you are not able to properly brief a case, you will not be able to properly apply it. And at the end of the day, that can really, really impact your knowledge. It can impact your grades when it comes to school. So it's very important to keep that in mind. There are a number of reasons why you need to brief a case. Some people ask, do you have to brief cases? I think every law student has to brief cases, especially in their first year of studies. It's so important. I'm not saying that you can't rely on other people's case briefs. For example, older students' case briefs or case briefs in textbooks. In my opinion, you can't rely on them. But at the same time, it is important to have your own case brief because it helps you better understand the case when you actually brief it yourself. And also, it's easier for you to remember it. And the process of case briefing is very important. It's something that you have to grasp. At least by the end of your first year, you should be able to know how to brief a case. And then later on, as time goes on, maybe you can rely more on other people's case briefs, as long as you know how to brief a case yourself, just to make that clear. So the question is, why do you even need to brief a case? The very first reason why you need to brief a case is because you have to learn how to read a case. You have to learn how to find issues in a case. A lot of law exam questions are in a problem question format where you would have to identify issues. Learning how to brief a case helps you learn how to identify issues in a case. So that is very, very key. And this is why, as I already mentioned before, as a first year law student, you have to learn how to brief a case, because as you are learning to brief a case, you are learning how to read a case, how to understand a case, and how to know what is most important in a case. And of course, it will help you in answering law exam questions. You also need to brief cases for class discussions and tutorials. A lot of the time in class, whether it's a lecture or in tutorials, the lecturer can call on you to talk about a particular case. And your case brief is going to be your first point of reference. Once you brief the case and you have it on your laptop or you have it in your notebook, you can just refer to that short case brief to give you an idea of what the case is about in order to answer your lecturer's question. These situations can be a bit uncomfortable, and that is why you need something that you can refer to as quickly as possible in order to answer the question correctly or to engage in discussions during tutorials. Another reason why you need to learn how to brief cases is to be able to identify the rule of law in every case, and also to be able to see how a particular rule of law applies to a set of facts. Again, this goes to answering exam questions, because once you see how a particular rule of law applies to a particular set of facts, you can do the same thing when answering a problem question. And then if we take this a bit further, of course, if you're going to be practicing law, you're going to be applying certain rules of law to real facts, so to real situations. And that is how we are generally trained, especially with the use of problem questions during exams. When you're answering a problem question, that problem question is like a real set of facts. So those events could happen in real life, and you, as a potential legal practitioner, you are identifying issues in that set of facts, and then you are applying the law to that set of facts. So learning how to brief a case helps you in this learning process of how to do exactly that. Okay, so a lot of people ask this: how long should a case brief be? So ideally, a case brief should be half a page, or as short as possible, as short as you can possibly make a case brief. That is how you should do it. Generally speaking, 1 page in Microsoft Word or in your notebook should be like the maximum that your case brief length should be. But then again, as I already noted in the beginning of this video, do what is right for you. If you are able to navigate a case brief which is 2 pages long, then that is fine. You should abide by that. But most people cannot handle that. Most people need something which is really, really short to be able to navigate and get the general idea of a case as fast as possible. And I would like you also to note that even when watching this video, you might be a bit confused if you're just now starting out law school. It's natural. It's perfectly fine. You shouldn't worry too much. As long as you do the necessary readings, you go for the necessary lectures, you ask questions, you go for tutorials, you will gradually get the hang of reading cases and briefing cases. It's normal, perfectly normal to be confused. And even with this video, if you're watching right now and you're just thinking, God, what is she even talking about? Like, I don't know what she's talking about. It's okay. Just take in this information, try to understand it the way you understand it now, and take it with you as you progress in your studies. By the end of first year, if you haven't yet grasped how to read and brief cases, then you should start getting worried because you know that you have a problem. So what information should you include in a case brief? First and foremost, of course, you have to include the name of a case. So Fisher and Bell. Then we move to the court name. And just to make it clear, all of this information you get from the case, from the actual case. Yes, when you're making a case brief, make sure that you get the actual case, whether it's in the hard copy law report or you have the case in soft copy. You have to get the actual case to be able to properly brief a case. Don't rely on someone else's brief or on a textbook to be able to brief a case, because the information that you're going to get is already summarized and it's not summarized by you. So you have to do it yourself from the actual real case. So when it comes to the court name, again, you'll find this information in the case. It can be, for example, in the Supreme Court, in the Court of Appeal, in the High Court. That's the court name. The next thing that you would need to include in your case brief is the relevant facts from the case. So the relevant facts are basically a story. What happened in the case? Someone stole a bag from someone else. Those kinds of just narrative facts. Usually you can summarize them into just a couple of sentences depending on what happened. When it comes to the facts of a case, they can be 3 pages long depending on the sequence of events of what happened in the case. But you would only need relevant facts. So that is the facts that relate to the issues at hand and the facts that relate to the rule of law at hand, which I'm going to be talking about a bit later. The next thing you would have to include in your case brief is the procedural history. That is basically just the history of the case. What course did the case pass through? If, let's say, you are reading the case at the Supreme Court stage, you have to state that the case went to the High Court. the judge ruled this and this at the high court level, the case went to the court of appeal, the judge ruled this and this at the court of appeal level, and now the case is at the Supreme Court. Sometimes people also include the arguments of the parties, so what the plaintiff and what the defendant contended at every point in time, the high court, at the court of appeal, at the Supreme Court. And now we come to the issue or the issues. In some cases, we have multiple issues. In other cases, we have just one issue. So the issue is basically the legal question that the court had to decide on. And the answer to the issue is usually also what determines who wins the case. The issue is usually a question in the form of whether or not. So if we take once again the famous case of Fisher and Bell, an issue, for example, in that case was whether or not the display of a knife in a shop window constituted an offer for sale or an invitation to treat. Now, as I said, the answer to the issue is what can determine who wins and who loses in the case. So with this particular issue, for example, if the display of the knife constituted an offer for sale, then the defendant would be guilty. And if it was merely just an invitation to, then the defendant would not be guilty. So that's how issues work. And with time, you would be able to spot the issues in a case. Sometimes the judges themselves in the case would say the word issue. They would say the issues in this case are, and then they would start listing them. So that's just an easy way to spot out an issue or issues in a case. Next, we move to the holding. The holding of the case is related to the issue of the case. So as I've already mentioned, when it comes to the issue, it is a question. The holding is basically an answer to the question. So in reference to the issue that I've already mentioned, yes, the display of a knife constitutes an offer for sale. That can be an example of a holding. Or the display of a knife constituted an invitation to treat. That can be a holding. It's usually just one sentence. Next, we come to the court's rationale or the court's reasoning. And in this part of the case brief, you explain why the court held what it held in the holding. So if in the holding you said that the display of a knife in a shop window is an invitation to treat, in the reasoning you explain why the court held that. Usually, to find the court's reasoning in the case, you should watch out for that part of the case where the court narrates what each party said. So usually the judge would say something like, the appellant in this case contends this and this and that. The respondent contends this and this and that. So after that, the court usually gives an analysis of its reasoning as to why it holds what it's holding. And a lot of the time, with the reasoning, we add the rule of law. Now, the rule of law is the most important part of a case. It is basically what you would need the most in a case, and your primary goal is actually to identify the rule of law in a case. So the rule of law is also referred to as a principle. So the principle in the case. So if we take the case of Fisher and Bell, for example, the principle in that case is that the display of goods in a shop, even with prices attached to it, does not constitute an offer for sale, but merely an invitation to treat. So this principle of law is a general principle which we can pick out from this case. And this is the principle that you will be applying when you are answering law questions. So that is the most key thing. And usually this principle is tied in with the reasoning or the rationale of the court. Depending on the number of issues that there can be multiple holdings, multiple reasonings or rationale of the court, and multiple rules of law. Sometimes there can be one rule of law, but multiple rationales. And then we have the conclusion of the case. So that is, who did the court hold for? Did the court hold for the plaintiff or the defendant? Did the court affirm or reverse the case? It's usually just one statement, just finalizing everything in relation to the case. Sometimes it's also important to talk about the dissenting opinion, because in some cases the dissenting opinion plays a very, very large role in the future development of the case. A lot of the time we can see that in cases where Lord Denning had a dissenting opinion, sometimes his dissenting opinion crystallized into a rule of law in other cases, in later cases. So that is why in some cases it is important to look at the dissenting opinion. So this is basically an in-depth way to brief a case. And as I stressed in the beginning of this video, it is important for you to go in depth like this when you are starting out to brief cases in order to help you learn. As time goes on, you will start focusing on only certain things. You will start focusing on only the name of the case, the facts of the case very briefly, and sometimes you might not even have to consider the facts of the case. and then the holding and the principle in the case. Sometimes in certain exceptional situations, you might also have to talk about the dissenting opinion. But the most important things in the case primarily are the facts of the case and the holding slash principle in the case. That is what you're going to be using most of the time. And also keep in mind that you shouldn't spend too long briefing cases. It can take up a lot of your time, which is completely unnecessary. As you progress later on in your studies, you have to find a way to brief cases as quickly as possible by skim reading primarily. So that's my biggest advice, just an extra tip on how to read and brief cases. Develop the habit of skim reading so that you can literally go through a case, which is, let's say, 25 pages in a matter of maximum 30 minutes. By skim reading and finding what is most important in the case and moving on. If you have any questions for me, please leave them in the comment section down below. I try my best to reply to Instagram DMs as quickly as I can, but sometimes I can delay with Instagram replies. But I do reply questions that are asked in the YouTube comment section, so make use of it. And I hope this video was helpful, and I hope I'll see you in another video. So thank you very much for watching. Bye!